And welcome, everyone. We're about to get into, I guess, the best way to describe it is controversial, provocative, and those are certainly good words. But even better than those good words, controversial and provocative, there are two better words: informative and factual. So in the next 40, actually no, it's going to be the whole show. For the next 60 minutes or so, I'm going to be talking to you about two provocative topics, and I'm going to be talking to you about two controversial topics. But they really shouldn't be provocative, and they really shouldn't be controversial. Um, Initially, I was planning to speak only about something called critical race theory, and I'm going to get to that. Don't get me wrong, I'm going to get to that. But as you know, 2 days ago, the Pennsylvania Supreme Court issued a ruling in the Bill Cosby case. And that news story blew up. I mean, everybody all over social media is talking about it. Either they think it's the greatest decision in the history of the court, or they think it's the worst decision in the history of the court. They think that it's pro-Black, or they think that it's anti-woman. I mean, people have strong positions on this. But I want to cut through all that. I want to cut through all the emotions on all sides and simply lay out the law and lay out the facts. So again, two topics. The first topic will be Bill Cosby and what really happened in that Supreme Court decision. And the second topic will be critical race theory, what it is and what it's not. And it's really interesting because as I had already prepared for the critical race theory component of today's show, but it wasn't until earlier today that I said, wow, this Cosby case situation is really blown up. This is the TV courtroom show. I am attorney Michael Cord, so I should bring that in. And as I decided to bring in the Cosby case decision in connection with my critical race theory, it's amazing how things work because it all comes together. It's all about the law, whether we're talking about Bill Cosby or whether we're talking about critical race theory. It's all about the law. So, folks, have a seat. Professor Michael Cord, aka Attorney Michael Cord, aka Michael X, aka the angriest Black man in America, is about to start this lecture. And I encourage folks to record this. If you're not recording it, please make sure you're watching it on Comcast 66 or 966, and also Verizon Fios. Those channels are 29 and 30. And always remember, you can always check us out, Facebook live stream, and you can check us out at phillycam.org/web.channel. I'll give you all that again. Check us out on Comcast channel 66 or channel 966. Check us out on Verizon Fios. That's channels 29 and 30. Check us out at Facebook live stream, and also check us out at phillycam.org/web-channel. Having said that, let's do this. And please, folks, like I say, watch it on TV, record it, and pull out your pens and pads and jot some stuff down, because what you think you knew about the Bill Cosby case, you probably really didn't know unless you read the entire 79-page opinion and researched the cases that the court cited in that 79-page opinion. And you probably didn't do that. I did. And in regard to critical race theory, you probably hear people on TV talking about it, but they have no idea what the hell they're talking about. So we're going to set the record straight, starting off with the Bill Cosby case. But in talking about the Bill Cosby case, let me explain how the criminal law system works. And as I said, I am Michael Cord, attorney at law. I've been a trial attorney for 26 years. I know I look like I'm only 33, but yeah, I've been a trial attorney for 26 years. So I kind of sort of know what I'm talking about and didn't just Google some stuff last night on the internet and then come out here. And by the way, folks, please stay in your lane. You know, I don't know anything about cars, so you won't see me posting anything about cars. I don't know a whole lot about sports. I mean, I played sports, but I'm not a professional athlete, so I don't really offer any comments about strategies in sports. I know nothing about plumbing, so I will post nothing about plumbing. I would encourage folks to take a page out of my book and stay in your lane. If you don't know what the hell you're talking about, don't talk about it. The major problem I have with social media is that it's given a camera and a microphone to everybody. And most of the folks, I'd say 98%, have no idea what the hell they're talking about. And don't tell me you have your right to your opinion. Yeah, you do. But opinions are not facts. Opinions are like buts. I don't want to say the bad word, but opinions are like behinds. Everybody has one, and most of them stink. So please don't get on social media talking about the law in regard to the Cosby case if you don't understand the law. Don't get on social media chastising or condemning the critical race theory if you don't really know what it is. And that's what I'm here for. I'm here to enlighten you. I'll talk to you about the stuff I know about. The Cosby case, I know about. Critical race theory, I know about. Professional sports in terms of giving my opinion, no big deal. Plumbing, carpentry, auto mechanics, I don't know anything about that. So I won't be posting anything about that. So let's get back to the first part of the two-part lecture. First, once again, the Supreme Court decision in the Cosby case. Number two, critical race theory. Now, in regard to the Cosby case, you need to understand a couple things. One, it was a criminal case. And in all criminal cases, you need to understand that, and this is going to shock you when you hear it, but it's going to make sense. Criminal trials are not about what a defendant did on the street, but are only about what a prosecutor does in a courtroom. Let me repeat that. Criminal trials are not about what a defendant did on the street, but only about what a prosecutor did in a courtroom. Let me give you an example. I represented John Lewis. And John Lewis, several years ago, was accused of killing Officer Chuck Cassidy. And many people who know me know that I don't have any love for the cops. But I got to give a major shout out to Officer Chuck Cassidy, a real hero, a great cop, and a great human being who tragically was killed by my client. And I respect officers like Chuck Cassidy because they are not bullies. They are not thugs with badges. And it's tragic that this heroic police officer, Chuck Cassidy, was killed by my client. Now, as many of you know, that killing was videotaped. It was a killing at Dunkin' Donuts on Broad Street, and they obviously had the cameras inside Dunkin' Donuts. So although the public didn't see everything, I saw everything, and some reporters saw it. I'll never forget the first day of the preliminary hearing. I'm going into the Stout Justice Center at 13th and Filbert, across from the Criminal Justice Center. And there's a whole bunch of reporters and cameras and recorders and all that. So as I'm trying to get the reporters to get into the courthouse, a reporter sticks his microphone in my face and has the camera right in my face, says, Mr. Cord, your client is on video murdering a police officer. What are you doing? And I turned around slowly and said to the reporter, okay, we got two options. We can either take my client out back for a lynching, or we can take him upstairs for a trial. The choice is yours. And the reporter had the dumb look because he realized in a criminal case, it's all about procedure. It's all about proceedings. It's all about process. It's all about due process. Another example, we all saw Derek Chauvin murder George Floyd. But despite the fact that we saw it on video, he still had a trial. He still had a proceeding. He still had a jury. He still had due process. So that's why I said at the outset, criminal trials are never about what a defendant did out on the street or at home or at work or whatever. Criminal trials are only about what a prosecutor does in a courtroom. Let me continue. And I know you folks are writing this stuff down, and I really appreciate you doing it. Several reporters recently asked me what I thought about the Bill Cosby ruling on Wednesday by the Pennsylvania Supreme Court. And one of the greatest was done by the Philadelphia Tribune, which, by the way, I write for. And what I told the Tribune reporter and other reporters is that the Pennsylvania Supreme Court issued a good ruling for a bad man. Let me repeat that. And by the way, big shout out to our producer engineer, Roland. He's actually put up an article I wrote a long time ago. In fact, back in 2018, right after the verdict, I wrote an article in the Philadelphia Tribune about Bill Cosby. And the article is entitled, "Cosby Probably Wishes Shaniqua Was on the Jury." And I'll explain what I mean by that later, but I got to give myself a pat in the back. It was prophetic. I wrote this in 2018, and here we go 3 years later, 2021, and the Supreme Court does in 2021 what I said they were definitely going to do in 2018 after the verdict. So I'm going to talk more about that later, but when I say that Bill Cosby, or rephrasing it, when I say the Pennsylvania Supreme Court issued a good ruling for a bad man, I mean that. And I know I'm going to lose some street cred because my comrades in the Black community, my family in the Black community, they think that I'm going crazy, that I went to the dark side. They think that I lost my cultural bearings because I said Bill Cosby did what he is accused of. The same kind of thing happened after the O.J. Simpson trial. I said the same thing. O.J. killed those people. And it's funny because even though O.J. did it, if I were on the jury, I would have voted not guilty for O.J. Even though Bill Cosby did it, if I were on the jury, I would have voted not guilty. People say, well, Mike, if you think O.J. Simpson killed those two people, if you think that Bill Cosby committed rape or sexual assault, why are you finding both of them not guilty? Well, the answer is legal and cultural. Let me give you the cultural answer first. Even though I'm a lawyer, I don't trust this legal system. If a Black person is caught up in this racist legal system, I'm giving that Black person all types of reasonable doubt. I'm giving that person more than reasonable doubt. I'm giving that Black person more than the benefit of the doubt because I know about America's racism. I know about America's racism in the legal system. And when I get to my next topic today, dealing with critical race theory, I'm going to break it down to you. So the reason why I gave the benefit of the doubt to O.J. Simpson and to Bill Cosby, even before all the evidence was in, is because I know this is a brutally, blatantly racist, criminal so-called justice system that grinds Black people up, especially Black men up. And I'm not going to be a party to that. So that's the cultural reason. But there are some bad Black people who do some bad things and they ought to be punished. That's where the trial comes in. So now I'm going to give you my legal reason. In regard to O.J. Simpson, there were several things. The key witness was a lying racist cop who not only frequently used the N-word, but lied about it. So if your chief prosecution witness is a lying cop, how does that prove O.J. guilty? If the DNA was destroyed because some dumb cops kept it in an SUV for 24 hours and that caused serious damage to the evidence, that's not O.J. Simpson's fault. If the glove didn't fit, and by the way, that glove probably did fit, but the prosecution was so stupid. They had to know what everybody knows, or should have known what everybody knows about leather. What happens to leather when it gets wet? You guessed it. It shrinks. Water is in blood. So if OJ had this bloody glove, that means it was a wet glove. And if it's a wet glove, there's water in it. What does water do to leather? It shrinks it. So instead of having OJ try to force that glove on in the courtroom, what the prosecution should have done is to have a cop who was about the same height and weight of OJ, and at the police station, do a practice run. Have that cop try to put that glove on and videotape that and bring that as evidence. So it was a horrible prosecution against a killer. And because it was a horrible prosecution, OJ was supposed to be found not guilty. And I want to be clear. When a jury finds a defendant not guilty, they're not saying you're innocent. They're saying you're not guilty. People say, what's the difference? Not guilty means the prosecution did not prove it. Innocent means the defendant did not do it. But in a criminal trial, juries are not told by the judge to even consider innocence. The only thing the judge tells the jury is that, ladies and gentlemen, you got to go to the deliberation room and you got to decide guilty or not guilty. That's your only choices, guilty or not guilty. The judge didn't say guilty or innocent. The judge said guilty or not guilty. That's why I could have been a juror in the OJ case, and I could have been the foreperson. And I would have said, hey, how many people here think OJ did it? I would have raised my hand. And I would have said, how many people here think that OJ is not guilty? I'd have raised my hand again. And they'd say, well, how can you say he did it, but he's not guilty? It's very simple. The law is not about what a defendant did. The law is about what the prosecution can prove. And that's a good thing. I got some serious problems with the legal system and how it works, but I got to give credit where credit is due. The whole notion of a trial, the whole notion of presumption of innocence, the whole notion of burden of proof, the whole notion of beyond a reasonable doubt, that's an important thing. A great Supreme Court justice from the 19th century said, it is much better that 10 guilty men go free than one innocent man go to prison. Let me repeat that. It's better, and I'm going to update it. It's better that 10 guilty people go free rather than one innocent person go to jail. So we have to go by the rules. What's the rules? The rules are the process, the due process. Even though we saw Derek Chauvin kill George Floyd, the system didn't simply grab him up and throw him in prison, even though we saw it, because that's not the process. The process is you have the right to an attorney. The process is you have the right to a preliminary arraignment where your bail is set. The process is you have the right to a preliminary hearing where they decide if there's enough evidence to schedule a trial. The process is to have a formal arraignment when you get all the evidence against you. The process is to have a pretrial conference to argue motions to get certain evidence thrown out. The process is to have a scheduling conference to set a trial date. The process is to have a trial with a jury involving jury selection. The process is to be able to file post-sentence motions. The process is to be able to file an appeal. All that stuff I just laid out, that's due process. And there's much more. Even though Bill Cosby did what he was accused of, the process wasn't fair. And I'm going to prove to you that OJ did it. And I'm going to prove to you that OJ did it too, but I'm going to prove to you that Bill Cosby did it. And I'm going to prove to you that he did not get a fair trial. Not only should he have never been tried, he should have never even been charged. And I'm going to tell you about the due process thing. So anybody who's not feeling me right now, anybody who disagrees with what I'm saying, go back to what I told that reporter in my John Lewis case. Yes, John Lewis did brutally murder a heroic police officer. So what do we do about that? Do we simply grab him up at the Dunkin' Donuts after the shooting and put him on death row? Do we simply grab him up and throw him in state prison for the rest of his life? Or do we go through the process? And if we go through the process, it has to be due process, consistent with the Constitution. So you can't have it both ways. You can't say, hey, I support due process and Bill Cosby should be in jail. You're a hypocrite if you say that. But if you want to be honest and say, yeah, he's a black guy and he did this stuff to these white women, so the hell with him, throw his ass in jail. If you say that, you're a racist, but at least you're an honest racist. And I can respect that. But don't act like you support the whole notion of the United States Constitution and then turn around and say OJ, and I keep calling him OJ, same kind of situation where they did the crime, but were found ultimately not guilty. So I want to be clear. I believe, correction, I know Bill Cosby did it. but I know that he did not get a fair trial and therefore should be home with his wife and family. You might say, well, Mike, how the hell do you know that Bill Cosby did it? Because I'm taking him at his word. He said he did it. That's what the whole case is about. He said he did it in a civil deposition. I'm going to talk about that later. And when the only reason he said it in that civil deposition is because the former district attorney in Montgomery County said, okay, Bill, we think that we don't have enough evidence for a criminal trial against you, but we believe you did some stuff to these women. So these women are suing you and you ought to pay them for their pain and suffering. So go ahead through the civil case, admit what you did, pay them the money, and we promise you, because you are paying these women for so-called pain and suffering, we won't prosecute you in a criminal case. So Bill sat down at that deposition and said, yeah, I did it. This is how I did it. I'm going to read to you what he said. That's why the Supreme Court said, no. When that prosecutor told Bill Cosby he can go ahead and admit to what he did because they weren't going to charge him in a criminal case, that's the only reason Bill Cosby admitted what he admitted in the civil case. So if the prosecutor had been honest, in fact, the prosecutor was honest. It was the second one that tried to do an end around. But the first prosecutor said what he meant and meant what he said. He said, hey, I'm not going to prosecute you. Go ahead and say what you need to say and pay these people. And Bill Cosby relied on that, and they used that against him in a criminal case. Bill Cosby would not have admitted anything in the civil deposition if the DA's office hadn't promised him that they weren't going to use it against him. And if he didn't admit it in the civil deposition, then the prosecution would have had a very weak case. Remember, the first time it was a hung jury in Bill Cosby. And both of the times they're using Cosby's words against him from the deposition. So if you don't have the deposition, you don't have a confession. If you don't have a confession, you don't have a case beyond a reasonable doubt. Bill Cosby should never have been tried. Now, let me go back to my initial point. As I said, the Pennsylvania Supreme Court issued a good ruling for a bad man. And when you go to court, it's not about what you did. It's only about what the prosecution can prove. Let me repeat that. It's never about what you did. It's only and always about what the prosecution can prove. Now, let me just say this quickly. I'm definitely going to get in about 10 minutes. I'm going to get to the critical race theory, but I gotta talk to you folks about Bill Cosby and why the Pennsylvania Supreme Court issued a good ruling for a bad man. And then people say, okay, Mike, I hear you. Yeah, I guess it was a good ruling, but it was only a technicality. No, it was not a technicality. Unless you believe the U.S. Constitution is a mere technicality. No, the U.S. Constitution is much more than a mere technicality. It is the fundamental law of the land. And in the Fifth Amendment to the U.S. Constitution, it says clearly that all defendants are protected from unlawfully incriminating themselves. You've seen those gangster movies where, you know, the police are trying to question somebody or a prosecutor is trying to question somebody, and the person says, on the advice of counsel, I assert my Fifth Amendment right to remain silent and not to incriminate myself. Okay, that makes sense. You have the right to do that. So the Fifth Amendment said people should not be forced or tricked into incriminating themselves. You may say, well, why? It's a good reason why. Because if the police can use your confession against you without anything else, all the cops got to do is grab up anybody they want and beat the slop out of them. And once the cops are beating you, you'll confess to anything. That's why it takes more than a mere confession. And if it is a confession, it has to be consistent with your right against unlawfully incriminating yourself. I need to repeat that, but slow it down because I want people to understand what I'm talking about. The Fifth Amendment says that the prosecution cannot beat or force or trick you into incriminating yourself, because if the Constitution allowed that, then that would encourage cops to just beat up everybody and get everybody to confess on themselves falsely. And now that the police got this confession, they can use it against Bill Cosby, Michael Kort, anybody else. But they need more than that confession. And by the way, if they get that confession, I don't want to get too technical, but the way we lawyers frame it is this. Any confession has to be knowing, intelligent, and voluntary. Those are three legal terms: knowing, intelligent, and voluntary. Knowing means that you were awake, you were alert, you weren't asleep, you weren't drunk, you weren't high. Intelligent means you understand the consequences of your confession. You know that, hey, if I say I committed a crime, I can go to jail. And the last one, voluntary, means that you weren't beaten, you weren't forced, you weren't tricked. Bill Cosby was tricked. He was deceived. He was misled. He was lied to, because you had one DA, and I'm not talking about an assistant DA in the courtroom. I'm talking about the duly elected DA who told Bill Cosby, hey, Bill, I know you're being sued in these civil cases, and I know that you're inclined not to say anything in those civil cases, because if you admit to doing something wrong, we can use the evidence from that civil case. And by the way, it wasn't a civil trial. It was a pretrial proceeding. Before you get into court on a civil lawsuit to get money from somebody, your lawyer files a lawsuit. And when he or she filed or they filed that lawsuit, you have what they call pretrial proceedings, and they include interrogatories and depositions. Interrogatories are when a lawyer wants you to write down your answers to his or her or their questions. Depositions are where you have to go into the other lawyers, the opposing lawyers. So let's say Michael X sues Joe Blow. Well, I sue Joe Blow, and then before the trial, I'm suing Joe Blow on behalf of my client because Joe Blow injured my client in a car accident. So I'm suing Joe Blow. But before we get anywhere near the courthouse, I'm talking about months before, years before, I subpoena Joe Blow to come to my law office. And I got a court reporter in there, a court stenographer. And I asked Joe Blow a series of questions. And he has to testify, because it is a testimony, it's under oath. So Joe Blow is in my office, and I'm asking Joe Blow, were you driving on May 19th? Were you at Broad and Walnut? Were you drunk? Were you speeding? Were you whatever? And Joe Blow is answering that. So once Joe Blow answered, I can use his answers from that deposition against him at the trial if he tries to say something different later. Well, the prosecutor in the Bill Cosby case wanted to make sure that the lawyer suing Bill Cosby could just deal with that civil lawsuit, get some money for his, her, or their client, and the case ends there. That the district attorney wouldn't come in and use what Bill said in that civil deposition against him in the criminal case, because the DA from Montgomery County at the time, he made it clear. He said, hey, the only reason I agreed is because there wasn't enough evidence to convict Bill Cosby, that it was a very weak prosecution case. And as a prosecutor, I wanted that woman or those women to get something. They can get money from Bill, they can get therapy, they can get counseling, they can do whatever. But if I, as the prosecutor, say, hey, Bill, I'm coming after you, Bill's going to shut down in the civil case. And those women won't get anything. And if they do, it's going to take decades before they get it. So the prosecutor from Montgomery County felt that in order to provide these victimized women with something, he would allow Bill Cosby to testify in that civil deposition, pay those women for pain and suffering and emotional distress and mental anguish and anything else they can think of. That way they would get something. But if that prosecutor said, Bill, I'm coming after you, Bill's lawyers would not have allowed him to testify in that civil deposition. The only reason Bill Cosby made that incriminating statement in the civil deposition is because the duly elected DA of Montgomery County told him that they would never use Bill's civil deposition testimony against him in any criminal case. Bill said, okay, I'm clear. And you say, well, Mike, why do you say you know Bill Cosby did it? And remember what I'm saying. He did it, but he's not guilty. Let me repeat that. Bill Cosby did it, but he's not guilty. The fact that he did it is irrelevant to a criminal trial. The only thing relevant at a criminal trial is, can the prosecution prove the case beyond a reasonable doubt consistent with due process? And due process simply means the process, the procedure, the rules. So if you violate the rules, I mean, in basketball, the guy's defending me. I can punch him in the face and then lay the ball up. And if I punch him in the face every time, I'm free to lay the ball up. And I can score 1,000 points doing that. But the rules don't allow me to punch the defender in the face, knock him down, and then score the basket. It just doesn't allow that. And just like there's rules or due process in basketball, there's rules, due process in a criminal trial. And the prosecution can't tell you one thing on Monday and turn around and do the exact opposite on Tuesday. That's not due process. That's a violation. Now, you might say, Mike, why do you say that Bill Cosby did it? Let me just read to you. And by the way, I encourage folks to get that article I wrote in the Philadelphia Tribune. In that article, I make it clear that Bill Cosby did what he was accused of, and you can read the entire article for yourself. It's from 2018. Our producer, Roland, put it up on the screen earlier. He's going to put it up again. And just Google it. Just go to phillytrib.com. The article is from April of 2018, and it breaks everything down. I'll get to that whole Shaniqua thing in just a second. But check out the article, phillytrib.com, from April of 2018. It's entitled, Cosby Probably Wishes Shaniqua Was on Jury. Check that out. But let me get to the part about where I say that I know Bill Cosby did it. And this is included in that article. Let me just read that. It's only going to take me a few seconds. Let me just read it. It goes like this. By the way, before I proceed any further, I must say this. I am no Cosby apologist. I believe he's a serial sexual predator who did exactly what Andrea Constant, as well as the 58 other women, accused him of doing. My belief is based not only on what she credibly testified to in court and what those nearly 60 others who, by the way, didn't know each other, but gave eerily similar credible accounts, what they said during separate televised interviews. And it's also based on what Cosby himself said under oath during a 4-day, 1,000-page deposition in 2005 and 2006. So in 2005 and 2006, beginning in 2005, the lawyers for the women sue Bill Cosby. There's a deposition. Bill Cosby has to come to the lawyer's office and state what happened or didn't happen. He would have said, I'm not saying anything. I assert my Fifth Amendment right to remain silent. But he said, okay, I am going to tell you what I did. I am going to talk about it because I just spoke to the prosecutor, the district attorney yesterday, and he told me I'm free to say anything in this deposition. And he assured me he would never use what I said in this deposition against me at a later trial. So based on that assurance, I'm good. So check this out. We're talking about the 4-day deposition in 2005, starting at end of 2005, ending in early 2006. And I'm reading this verbatim. When asked by one of the women's lawyers if he had ever given quaaludes to any woman without her consent, Bill Cosby responded, quote, I don't know, unquote. If you ask me at my age, if I ever gave a woman quaaludes without their consent, I would say, you must be out of your goddamn mind. I've never done that. Why would you say, quote, I don't know? Those are coming from Bill Cosby himself, but it gets worse. He also stated that he doesn't take quaaludes himself because they make him sleepy. And the only reason he ever had them was to give them to women he wanted to have sex with. That's Bill Cosby talk. That's not me. He said that. In addition, when the attorneys followed up on that, I was like, what? I can't believe you're saying this. And they said to him, these are rapes. These are sexual assaults. Bill Cosby said, no, they're not rapes. They're not sexual assaults. They are, quote, rendezvous, unquote. He called them rendezvous. That's his words. That's why I say Bill Cosby did it. But as cold as it might sound, it doesn't matter, because Bill Cosby was assured that his Fifth Amendment rights to the U.S. Constitution would be protected. But he was misled. He was deceived. And the Pennsylvania Supreme Court said, hold it. We're not going to allow this. This is absolutely outrageous. You can't tell a defendant one thing one day and then turn around the next day and say something completely different. You can't do that, and we're not going to allow it. And that's why the Pennsylvania Supreme Court did the right thing. The other thing I want to make clear, and this is an important factor, and I hope you all consider this. And a lot of this stuff I'm telling you about, if you don't catch it in the Philadelphia Tribune, you can definitely catch it on social media. You can follow me on Twitter. You can follow me on Instagram. That's Michael Coard, MichaelCoard. Michael Coard. That's attorney Michael Coard, AKA Michael X, AKA the angriest black man in America. This is what I posted on Instagram the other day. Check this out. Dear Cosby case so-called experts, if you haven't read the 79-page Pennsylvania Supreme Court opinion, or if you haven't researched constitutional due process, or Fifth Amendment self-incrimination protection, or Pennsylvania's Section 5947 immunity statute, or the Pennsylvania Supreme Court's ruling in 2018 in the Clancy case, in 2016 in the Martinez case, and in 2000 in the Krause case. If you haven't done all that, then please, with all due respect, shut up, because you don't know the law. You don't understand the law. You're just caught up in your feelings, and you're confusing everybody else, including yourself. Check that out on social media. The other thing I want to say before I get to the critical race theory is that when I wrote this article in April of 2018, not only did it go into why the jury got it wrong and why Bill Cosby should never have been convicted and why Bill Cosby shouldn't have gone to jail. It went into all that, and it talked about the legalities. It talked about not only the issue of his Fifth Amendment rights being violated, and that's a blatant due process violation, but it also dealt with something called Pennsylvania Rule of Evidence. That's Pennsylvania Rule of Evidence 404B. And I'm not going to get too nerdy and technical and lawyer-like, but let me just say this. Pennsylvania Rule 404B says that basically you can't bring in evidence of a crime or evidence of a wrong or evidence of another act just to show that the person was a bad person last week or last month or last year or last decade. And because that person was bad then, we can say he's bad now. Rule 404B of Pennsylvania Rules of Evidence say you can't do that. It also goes on to say something that's really important in connection with the rules. So we talked about 404B. And if you want to Google it, just Google Pennsylvania Rules of Evidence 404B. But don't stop there. Go to Rule 403. And 403 says not only is 404 right, but 403 goes further and says that, hey, if you're trying to bring in some evidence and that evidence has a danger of misleading the jury or confusing the issues or causing unfair prejudice, if there's even a chance that those things can happen. It's not that 403 says, hey, you can't bring it in if it causes unfair prejudice. You can't bring it in if it confuses the issues. You can't bring it in if it will mislead the jury. 403 says more than that. It says you can't bring it in if there's even a danger of those things happening. It's not just you can't bring it in if those things happen. You can't bring it in even if there's a danger of those things happening. Therefore, Bill Cosby's conviction could have been reversed based on a violation of Rule 404B and 403. It gets worse in terms of the due process violations. The trial judge, Judge Stephen O'Neill, he actually allowed 5 other accusers to testify against Cosby regarding incidents that were never reported, never charged, and it happened 40 years ago. That's just not fair. In addition, that same judge should have recused himself. Why? Because that judge's wife is a sexual assault counselor. And that's a wonderful thing. But you can't be married to a sexual assault counselor and then be fair in a sexual assault trial. And it's not even just a matter of the judge being fair. When it comes to judges, not only do they have to do the right thing, they have to have the appearance of doing the right thing. I would argue that it's not the right thing to be a sitting judge in a sexual assault case and be married to a sexual assault counselor. The law and the rules go further than that. It says that not only is it about not engaging in impropriety, but not engaging in what even appears to be improper. I'm not saying that this judge is a bad man. I'm just saying that based on my interpretation of the rules, he should have recused himself. And there's a bunch of other reasons, but I got to get to the critical race theory, and I'm going to spend my last 15 minutes talking about that. But in that article that you're going to read in the Tribune, not only does it talk about how Bill Cosby's rights were violated, and let me correct that. It wasn't just Bill Cosby's rights being violated. It was the Constitution itself being violated. So it doesn't matter whether it was Bill Cosby as a defendant or my lovely old grandmother. It simply comes down to the prosecution cannot cheat. The prosecution cannot lie. The prosecution cannot play unfair. And that's what the prosecution did here, and the Supreme Court fixed it. But the other thing I included in that article was my condemnation of Bill Cosby, because Bill got into this kind of elitist, snobbish, upper middle class, wealthy black thing. He did something called he gave something called the pound cake speech. Just Google pound cake and Bill Cosby. And what will come up is a speech he gave to the NAACP on May 17, 2004, where he attacked black people. He attacked hood black people. Here's exactly what he said. His exact words, quote, "Those people have names like Shaniqua, Muhammad, and all that crap, and all of them are in jail." And then he was chastising single mothers and unemployed black men. And it was just a bad thing for anybody, especially a rich black man, to say. So I got to tell you, I wasn't feeling Bill Cosby. But I know one damn thing. He wished Shaniqua had been on that jury. He wished Muhammad had been on that jury. But the fact that he would condemn names like Shaniqua, like Muhammad, and he called it all that crap, speaks volumes about this elitist approach to black people that Bill Cosby had. I need you to throw that out. Throw that out there so you can consider why I'm talking about what I'm talking about, the way I'm talking about. The other thing I want to just mention quickly, many people forgot about this. There was a juror number 11, and that juror, before the trial began, said this, quote, "I think Cosby's guilty, so we can all go home." Well, once a juror says that before the trial actually begins, you got to get not only that juror off, but you got to get other jurors off who might have been polluted and persuaded by that. But it didn't happen. Bottom line, Bill Cosby did not get a fair trial. The Pennsylvania Supreme Court did the right thing. So as I keep telling everybody, the Pennsylvania Supreme Court did a good thing for a bad man. But it doesn't matter in a criminal case whether it was a bad man or not. It doesn't matter whether it's Bill Cosby or my grandmother. It's all the same. And just quickly, and I'm going to give you 10 minutes of the critical race theory. Other problem I got is, did you know that there used to be the death penalty in the United States, not just for murder, but for rape. It wasn't until the year 2008 that the U.S. Supreme Court, in the Kennedy versus Louisiana case, for the first time, this country was founded in 1776. It wasn't until 2008, just 13 years ago, in your lifetime, my lifetime, your children's lifetime, your grandchildren's lifetime, that the Supreme Court for the first time said that it's unconstitutional to kill people for rape convictions. Think about that. And every time I hear about cases involving Black men and white women, I think about all of my ancestors, innocent Black men who were lynched or killed by the state because some white woman lied about a sexual encounter with a Black man. So all that's in my head, and all that should be in my head, and I make no apologies for it. By the way, what about the fact that a white man during slavery could rape a Black woman? Not only could a white man rape a Black woman, that white man could not be charged with the crime. In fact, that woman who was raped, just like these women sued Bill Cosby, a Black woman during slavery could not sue the rapist for rape. But check this out. Her quote unquote master could sue the rapist for damage to his property. The woman couldn't sue the rapist, but her so-called master could sue the rapist for damage to his property, and he gets the money. So don't talk to me about Black men and white women and rape and sexual assault and assume that I'm just going to take it at face value. I need to know more, because too many of my ancestors were lynched based on white women lying. And let me give you some statistics, and this is absolutely frightening. In 1816, the Georgia Penal Code, and I'm reading this verbatim, 1816, the Georgia Penal Code, quote, expressly provided that rape committed by a white man would be punishable by no more than 20 years. But rape by a Black person requires them to be put to death. Not only put to death for rape, but put to death for attempted rape. So don't get me started talking about Black men and white women and rape. And I know there were many serious white and Black and brown and other women and people like me who condemned Bill Cosby and should have. But I got to tell you, white women, be careful, because the same white women who were yelling and screaming about Bill Cosby, many of them voted for Donald Trump. Donald Trump said, I grab him by the genitals. He said that. Despite the fact that he said that, more than half of white women in America voted for Donald Trump after he said that. But those same women yelling about Bill Cosby, come on, make it make sense. Please make it make sense. Let me give you some more stats before I wrap up with critical race theory. Between 1877 and 1950, nearly 25% of all the capital punishment was based on charges of sexual assault, not murder, but sexual assault. 455 people were executed for rape in the United States between 1930 and that decision I mentioned to you, that Louisiana case from 2008. So between 1930 and 2008, where the U.S. Supreme Court said no more death penalty for rape, 455 people were executed for rape. Guess what percentage was Black? You're right, 90%. And of the 90% who were executed for rape, those Black men, in 98% of those cases, they all came out of Confederate states. So I want to be clear, about 90% of the people executed for rape convictions were Black. And of that 90%, 98% were from Confederate slaveholding states. What does that tell you? Well, I can't tell you what that tells you because I get to my critical race theory, but the segue is perfect because critical race theory is all about the law. And in my final 6 minutes, let me break this down. Keep writing, folks. It's going to be an exam at the end of the class. Critical race theory it's not what lying white racists claim it is. Once again, big shout out to Roland. He put the premier book about critical race theory up. I encourage you to get a copy. Critical race theory is not Black Lives Matter. Critical race theory is not reparations. Critical race theory is not defunding or defanging the police. And most important, critical race theory is not, I repeat, not taught and was never designed to be taught in preschools or in elementary schools or in middle schools or in junior high schools or in high schools. Critical race theory was always designed to be and still is taught in law school only. That's the first thing. So when you hear white folks running around saying, oh, they're going to force my little Johnny, little blue-eyed, blonde-haired Johnny and Susie to learn all this Malcolm X stuff in elementary school. No. Critical race theory is not designed for the schools. It's not designed for the preschool, not designed for the elementary school, not designed for the middle school, not designed for the junior high school, not designed for the high school. It's not even designed for colleges. It's designed for law school. It's a legal concept. One of the premier research authorities includes the Encyclopedia of Race, Ethnicity, and Society. And here's how they define critical race theory. They say critical race theory examines legal issues as they pertain to race and racism. And the ABA, the American Bar Association, breaks down what critical race theory is. And critical race theory wasn't created 2 weeks ago or 2 months ago or 2 years ago or even 20 years ago. Critical race theory is a concept that came into existence about 50 years ago. And it was created or invented or discovered by a law school professor, a Harvard law school professor who also taught at New York University Law School, Professor Derek Bell, a lawyer, a civil rights lawyer, a law school professor. And what he said is this: hey, everything that we see in regard to oppression in America is done through the legal system. It's the judges that send people to prison. It's the DAs that prosecute people. It's the cops that arrest people. All this oppression comes out of law. Well, the policy of America since 1619, when slavery began on August 25 in the Virginia colonies, the policy of America has been to be racist and to kidnap people and to transport people and to buy and sell people and to enslave people and to rape people and to lynch people and to castrate people. That's always been the policy of America from the very beginning when they encountered Black folks in 1619 in the Virginia colony. That's the policy. What's the enforcement of the policy? The enforcement of any policy, the muscle of any policy, is the law. You got to think it first as the policy, and then you legislate it as the law. So what Professor Derek Bell of Harvard Law School said is that we got to look at the law when we talk about racism, because all the illegal stuff, all the racist stuff done to Black people comes out of the legal system. So I want you all to understand, and you want some other names? Then there were other people who expanded upon what Harvard Law School professor Derek Bell came up with. There was Richard Delgado. What does he do? He teaches law at the University of Alabama Law School. What about Alan Freeman? Teaches law at Buffalo Law School. What about Cheryl Harris? Teaches law at UCLA Law School. What about Kimberly Crenshaw? Teaches law at Columbia Law School. In fact, it was Kimberly Crenshaw who later gave this concept the name critical race theory. When Derek Bell did it, he really didn't have a name for it. It wasn't until later that law school professor Columbia law school professor Kimberly Crenshaw, she said, hey, I see this thing, I'm feeling this thing, we're going to call it critical race theory. And it makes sense. Critical means to carefully evaluate something. That's what critics do. They carefully evaluate stuff. Okay, that's where the critical comes in. And then race. Well, we know that there's no such thing as race. Race is really a social construct. But in terms of how we use the word, race means the grouping of people based on their complexion and the texture of their hair. So when we talk about race, we're talking about that. And then theory. Theory is basically a plausible or scientifically acceptable process or principle or concept. So it's a theory if there's something factual to it, if there's something scientific about it. I would never question Professor Derek Bell. I would never question Professor Kimberly Crenshaw, but I like the term critical race fact instead of critical race theory, because theory implies that it's unproven. Well, when we talk about the law and racism, it's a fact. It's all proven. And in my final 2 minutes, I'm going to break it down to you. We talk about the law. Where does it begin? It begins in 1619 with the slave codes. Codes are laws. Codes are ordinances. So with the introduction of enslaved Black people on August 25, 1619 in the Virginia colony, we encounter the laws through the slave code. Okay, critical race theory. That's proof. What about the year 1630? That was when the first Fugitive Slave Act was passed in the Massachusetts Bay Colony. That's the law that's oppressing Black people. That's a fact. What about 1640, when 3 indentured servants ran away? Indentured servants are people who signed contracts saying, I'll work for you for X number of years. And back in the day, 1700s, you were locked into that for that term. Well, 3 men ran away from their indentured servitude period, their status, their contract. That's what it is, a contract. The 2 white men, when they got caught, their only punishment was that 4 years were added to their servitude. So they might have been contracted to work for 10 years. And once they ran away, it was changed from 10 years to 14 years. That's the 2 white guys. What happened to the Black indentured servant? In 1640, the Virginia General Court ruled that that Black man, quote, was to serve his said master or assigns for the time of his natural life. So the white guys got 4 years, the Black guy got life, based on American law, based on Virginia law. And then we fast forward to the year 1662 and 1667 and 1776 with the Declaration of Independence and 1789 with the U.S. Constitution and 1857 with Dred Scott. There's so much more I want to share with you, but run out of time. If you want more information about all this stuff, the Cosby case, you want information about critical race theory, email me at michaelcoard, that's MichaelCoard, the letter X, at gmail.com. I'll send you all this stuff. Read my articles at phillytrib.com. Catch me every Sunday from 11 a.m. to 1 p.m. on WURD 96.1 FM. I got so much more I want to share with you about the Bill Cosby case, so much more about critical race theory, but we run out of time. Don't worry, email me, michaelcoardx at gmail.com, or check me out every Sunday from 11 a.m. to 1 p.m. WURD 96.1 FM. Thank you, Roland. Thank you all. Have a wonderful weekend.